To dispense with any sort of long introduction of our very distinguished panelists, because most of you should know exactly who they are, and if you don't, bad on you. So I will just talk about their affiliations very briefly, and then we will go ahead and start the panel. So first we have Professors Wadhia and Walker. First up, they will be presenting their paper, and Professor Wadhia is at Penn State and Professor Walker is at Ohio State. So this is I suppose a football alliance of some sort. I don't know. Next, I believe we have Professor Masur, solely representing the Masur-Posner team from the University of Chicago Law School. Professor Posner, I take it, is listening in, but is unable to join via video. After that, we will have Professor Lawrence from the Emory Law School. And last but certainly not least, given our keynote article, if you will, we have Professor Choi from Minnesota, who will bring up the Minnesota quotient in our symposium. So with that, I will go ahead and let Professors Wadhia and Walker get started. That said, I will be timing you. I know that the last panel was very disciplined and kept to their 12 minutes, but you may or may not be so disciplined, so we shall see. And I will be timing you in order to keep you disciplined. And I will let you have an extra perhaps minute or so without my speaking. So please take it away, Professors Wadhia and Walker.
All right, well, thanks so much, Arti. This is a very Big Ten Midwest panel, and Matt used to be at Penn State too, so we used to all be here up in the Big Ten. So I'm really excited to be here with my co-author, Shoba Wadhia, to talk about our paper, The Case Against Chevron Deference in Immigration Adjudication. And this paper really is a direct follow-on to the lead article in the symposium by Kristen Hickman and Aaron Nielsen, where they make a broader argument about why Chevron should be eliminated or at least narrowed when it comes to adjudication. And so our main argument is straightforward, that in immigration adjudication, there should be no Chevron deference, that instead Chevron deference should apply when agencies in the immigration context are engaged in rulemaking. I wanted to go to the last part of my paper our paper before we turn over to Shoba to kind of get into the real details of our substantive argument. To just say, while Kristen and Aaron in their paper focus predominantly on how the Supreme Court should deal with Chevron, we do spend a little bit of time on what courts should do or shouldn't do. I tend to be a little bit of one of those old school, more judicial conservatives that believes in stare decisis, and so I'm not on board on the full project of eliminating Chevron by judicial action. So we really try to also focus on that in this context, and I think in other adjudication contexts, courts aren't the only avenue that we can have to make it reform. In fact, they're probably not even the best avenue when it comes to immigration adjudication. So in the paper, we focus both on, obviously, on the role of courts, but we also focus on the role of Congress, how that our reform proposal could be a very small part of a comprehensive immigration reform legislation that could come out of this 117th Congress from the Biden administration. And we also encourage the Biden administration to think about how the executive branch can reform Chevron in the immigration context on their own through internal administrative law, where the Attorney General decides not to ask for Chevron in adjudication, or where the administration more generally makes a concerted effort to move more of its major policymaking activities in the immigration context from adjudication to rulemaking. And I think that's a really important part of this conversation on the future of Chevron, that it really shouldn't just be about what the court should do with it. This should be a broader conversation of the role of the political branches in the process. And so that will shape the structure of our paper. We don't spend any time on congressional delegation, which for me is the core reason why Chevron exists. Instead, we go to the values of Chevron and evaluate those values, or those theoretical foundation of Chevron. You've already heard this from Judge Sutton in the keynote. Dick Pierce gave more overview of this, but the 4 values that we focus on in the paper are comparative expertise, deliberative process, political accountability, and to some degree uniformity of law. And today we're going to focus primarily on the expertise argument against Chevron in immigration adjudication. And I think this is all the more fitting after hearing Liz Fisher and Sid Shapiro talk about their view of administrative competence and expertise. So I'm going to now turn the rest of the time over. If there's a little bit of time, then I might talk a little bit more about the deliberative process. But I'm going to turn over to my co-author, Shoba Wadhia, who is one of the nation's leading experts on immigration law and the immigration adjudication. So, all right, Shoba, it's yours. My job is done.
Thank you, Chris. I do want to congratulate Duke Law Journal for putting together this symposium and journal. It's just been fantastic from start to finish. I also just have a lot to cover, so I have more thank yous, but they'll be offline. So I first want to just step back and provide a 101 on immigration adjudication, because it's an important foundation for how we then talk about the values of Chevron and whether they are met. There are a lot of things that we call adjudications in immigration law, but the focus of our paper is on removal proceedings. And removal proceedings start at the Justice Department with immigration courts. And then we also move to the Board of Immigration Appeals, as well as the Attorney General. And I don't want to overstate the structure of removal proceedings, because most non-citizens who are removed or deported never go to a courtroom. In fact, because of the immigration statute and the programs that are applied, the vast majority of people who are deported never go through a removal process. So for those who do go through a removal process, the preliminary hearing is called the master calendar hearing. The immigration judge will ask the non-citizen to respond to charges that have been brought by the government as an allegation of civil immigration violations. The next stage in the removal process is evidentiary. It's called the merits hearing. And so this might be where the non-citizen presents evidence, where there's cross-examination and even testimony by the non-citizen themselves. And this is also the forum where relief is a defense to removal. So that relief might include asylum, cancellation of removal, or adjustment of status. Immigration judges are employees of the Justice Department, and they play a significant role in removal proceedings. They wear black robes, but they're not administrative law judges or Article I judges. They also ask a lot of questions during these hearings, and they make decisions. Their decisions can be appealed by either the government or by the non-citizen to the administrative appellate body known as the Board of Immigration Appeals, which is one office building in Falls Church, Virginia, just to contrast that from the 60 or so immigration courts that are sprinkled through the United States. The Board of Immigration Appeals can publish different kinds of decisions, but if it's a published decision on a panel, that'll be precedential. That'll be afforded the Chevron deference that we've all been talking about. Another important piece of the adjudications process for this paper is the fact that the regulations allow for the Attorney General to certify a decision that the board has made to itself. Bijal Shah, who moderated the prior panel, has written a great article on this idea and concept. It is also afforded Chevron deference. We saw many of these AG decisions during the Trump administration, and we detail those in our article. So what are the cases that actually go to federal court, which is where the courts are actually making decisions about whether the Chevron framework even applies? That'll happen when there's a final order of removal. And I don't want to overstate that every case then goes to court, because the immigration statute has a lot of preclusions for, what's in and out for judicial review. But for those cases that can be brought to federal court, that's brought by the non-citizen through a petition for review to a circuit court of appeals. So there's the framework. And we really look at expertise, which is the heart of our article, And we really challenge whether there's any expertise when it comes to immigration adjudications. So if we look at, for example, scientific and technical expertise, there isn't really a lot of scientific expertise when it comes to immigration. And other scholars have also made the point that most of the decisions that are being made are legal questions, right? Interpreting complex statutes like, I don't have a slide, but here's the Immigration and Nationality Act, right? So a lot of these decisions are interpretations of that statute, but other times it might be looking at the Merriam-Webster dictionary. Another way you could assess whether there's expertise is to see the hiring requirements. So to be an immigration judge or even a board member requires no background expertise. You can look at the postings by the Department of Justice. There's general requirements around litigation or administrative law, but we don't really see immigration expertise as a centerpiece in the hiring process. Another way you could assess expertise is to see whether circuit courts refuse to apply Chevron deference. And Chris has done great empirical work to show that more circuit courts refuse to apply Chevron deference in immigration adjudications. And we give a window into the human face behind these cases, one including a woman who was the subject of extreme cruelty and abuse at the hands of her US citizen husband. And the court there was analyzing connected to, which is a language in the statute that was ultimately determined by the dictionary, not expertise. The whole time that this case was being decided and through the courts, this same woman was detained for over 2 years and with children. So I don't have time to get into the harms that flow, but there are some real harms. Legislative expertise. We don't really see any kind of deliberation with legislative experts by immigration judges or the board when it comes to making decisions. And craft expertise, which has been so beautifully articulated before. Yes, there's craft expertise when it comes to seeing the same types of cases, but how is that leveraged? There isn't really an interaction before these cases are decided. So I have about 30 seconds left, so I'm going to turn it back over to Chris and looking forward to your questions. Thanks.
Yeah, I would just add really briefly, I mean, the paper, we explore the other values. I do think that another value for shifting in the immigration context, Chevron to just rulemaking, not adjudication, is the public deliberation or the deliberative process, where you can not just leverage the expertise of the full agency better in a rulemaking adjudication, but you can also better leverage the expertise of folks outside the agency in really meaningful ways. And I think that's an important part of the story of expertise that we oftentimes separate out as deliberative process, but it really needs to be woven into that story of comparative expertise as well.
Terrific. Thanks so much, Professors Wadhia and Walker. Next, we'll move to Professor Masur.
Okay, great. Thank you very much. I've got a shared screen here, and this is a co-authored work with Eric Posner. And I would just note for the record that we think of our University of Chicago collaboration as really a football alliance also. So you can judge for yourself which is the more prominent football alliance. Okay, so our paper is really about the ways in which the Trump administration tried to use Chevron to get around cost-benefit analysis and get around the problems that cost-benefit analysis created for it. And what that says about Chevron, more generally, what that says about cost-benefit analysis, and what it says about what we think is a tension between the two of them. Okay, so the Trump administration was confronted with a problem. This is Trump's problem, not our problem. The problem was that Trump wanted to undo a whole slew of Obama-era environmental regulations, lots of other regulations as well, but we focus on the environmental ones largely because that's where we see the most sort of active role for cost-benefit analysis. But all of those regulations were supported by generally quite high-quality cost-benefit analyses that showed that the benefits of the regulations were going to dramatically exceed exceed the costs in most of these cases. We're talking about things like the Clean Power Plan, Mercury regulations, et cetera, showing vast net benefits in excess of costs. A lot of that is due to the work of Cass Sunstein, who was OIRA head during the period of time when a lot of these regulations were begun and when some of them were finalized. So that, of course, creates a legal problem for the Trump administration. The threat is that if they undo a regulation that looks like it's creating more benefits than costs, thereby creating themselves more costs than benefits and harming welfare, that could be subject to reversal under arbitrary and capricious review, APA 706. It also might get rejected under Michigan versus EPA, this 2015 case in which the Supreme Court said that it wasn't appropriate and necessary to have a regulation that had costs well in excess of benefits. So those cost benefit analyses, we think, serve a sort of, or were thought to serve a kind of entrenching function for the regulations. They justify the regulations, they show their welfare effects, and they make it hard for a subsequent administration to undo them without creating substantial legal trouble. So I want to sort of walk through three of these that we talk about in the paper and show what they looked like in the hands of the Obama administration and then in the hands of the Trump administration, and then the tactics that the Trump administration decided to use. So I'm going to talk about regulations, and I'm going to give you the bottom line Obama cost benefit analysis number, the net benefits that Obama thought that the regulation would generate. Then I'm going to give you the Trump number, and then I'll tell you the strategy that Trump was going to try to use to get around this problem. Okay, so the first one is the Mercury regulation. That was the subject of Michigan versus EPA. It was repromulgated after that decision with a cost-benefit analysis that sort of more effectively pointed to the benefits of the regulation and showed how dramatic those benefits were. The second one is the Clean Power Plan, which probably needs no introduction. And then last, I'll talk about this massive fuel economy standard regulation that Obama promulgated and then Trump rejected. Okay, so for Mercury, the Obama cost benefit analysis showed that there would be $52 billion in net benefits from the Mercury regulation, mostly in the form of people who wouldn't die from cancer as a result of curbs put on coal-fired power plant emissions of harmful chemicals. The Trump CBA, on the other hand, showed negative $9.6 billion in benefits from that regulation. So in other words, it showed that the same regulation was welfare diminishing instead of welfare enhancing. And of course, how did Trump get there? Trump got there by eliminating all of the co-benefits of the regulation. The Mercury regulation, sort of famously for Michigan versus EPA, produces relatively few quantifiable benefits from the reduction in mercury emissions itself, but very, very substantial benefits from the reduction in particulate matter emissions. So the Trump administration used Chevron and said that the statute was ambiguous as to whether or not co-benefits should be counted or not, and then said that as a matter of the discretion of the agency, it was choosing to interpret that portion of the Clean Air Act to exclude the consideration of co-benefits. And once you strip away all of the co-benefits from reducing particulate matter, you're left with a regulation that has benefits that are less than costs that exceed benefits. So we call this sort of a Chevron step 2 type argument. Their argument that the statute is ambiguous and that it's reasonable for them to interpret it in that particular way. The Clean Power Plan under Obama was estimated to produce $35 billion of benefits annually. Now, a lot of the criticism of cost-benefit analysis over the years has focused on the idea that cost-benefit analysis is potentially malleable, that you can, jigger with the numbers and make it say whatever you want. And so you can get whatever result we want. You can use it to justify anything or justify not doing anything, and that there's sort of no stickiness, no real there to cost-benefit analysis. So in that light, the Clean Power Plan was maybe the #1 regulatory target for Trump. You might have expected that Trump would just have his EPA produce a cost-benefit analysis that showed that the Clean Power Plan was actually bad and it was producing negative net benefits. They tried very hard. They made every move that they could reasonably or conceivably make. And in the end, the Trump cost-benefit analysis still showed that the Clean Power Plan was producing billions of dollars of annual benefits, which means that repealing it would produce net costs. Repealing it would be welfare diminishing. So that's a pretty bad look, all things considered. So what's the response? The response was to argue that the Clean Power Plan was unlawful at Chevron step 1. that in regulating outside the fence line, in regulating sort of the mixture of generation sources for a state's power plan, rather than just regulating any individual factory, the EPA had exceeded their statutory authority, and they had done so in the face of an unambiguous statute that precluded that move. So we call that a Chevron step 1 method of Chevronizing around this cost-benefit problem. They're trying to argue that the statute is unambiguous and precludes what the EPA and the Obama administration wanted to do. Okay, lastly, the fuel economy standards. Obama's agencies estimated those would produce overall lifetime benefits of $475 billion. Those are enormous benefits, needless to say, that would have raised the required fuel economy limits on cars and light trucks quite dramatically over the next decade. Again, here, Trump has an enormous incentive to try to produce a CBA that shows the opposite. But try as they might, and they did try, they initially produced one that yielded an opposite result, and it was so implausible and received so much criticism that they withdrew it. And the final cost benefit analysis showed that the net lifetime benefits of the fuel economy standards rule were actually positive, much smaller, obviously, only 13.1 billion, but nonetheless positive. And I think that the fact that even given all the incentives in the world to try to get that to be a negative number, and given an administration that's not exactly renowned for like playing tightly with the truth, the fact that cost-benefit analysis constrained them and that they could not get the number to be negative, I think is telling and important. Okay, so what's their strategy for getting around this? Prayer, I think. They didn't really seem to have a strategy. They were just sort of hoping that maybe a court would bless this, even though on its plain face, it's welfare diminishing. There was a separate issue about California seeking a Clean Air Act waiver to impose its own fuel economy standards. The Trump administration denied that Clean Air Act waiver, so California could not produce higher fuel economy standards. And they did that, again, it was a sort of Chevron step 2 type of strategy where they argued that the statute was ambiguous. Actually, it's a combination of 2 statutes, and that ambiguity they were going to interpret reasonably to bar California from receiving the Clean Air Act waiver. Okay, so what does all of this tell us about the strategy of Chevronizing around CBA? So Chevronizing at step 1, so that's again the Clean Power Plan strategy of just saying that the statute unambiguously bars what the Obama administration want to do. It just simply rested on a very dubious argument. I mean, the Clean Air Act is a broad and capacious statute. It's pretty hard to say that it unambiguously prohibits the regulation that the Obama administration was trying to promulgate. It's permanent. It has the sort of political value of being permanent, because if you can get a court to declare that the statute is unambiguous, then a subsequent administration can't come along and use its Chevron deference to undo what you've done. But of course, there's no fallback plan. If you lose at step 1, then you lose, your regulation goes down. And indeed, that is exactly what happened just a couple of weeks ago. This Clean Power Plan argument was rejected by the DC Circuit. So the way we see this is the fact of the cost-benefit analysis and how favorable it was towards the Clean Power Plan analysis, the Clean Power Plan regulation, forced the Trump administration into this kind of Chevron step 1 argument, which itself was legally tenuous, and then it turned out to be an argument that they lost. So they walked into a trap of their own making, and also of the making of the cost-benefit analysis. The Chevronizing at step 2 strategy, declaring, for instance, with regard to the mercury regulation, that it's reasonable to interpret the statute so as not to allow the counting of co-benefits. We see this as internally contradictory. You're interpreting your way into a welfare diminishing legal rule. You're basically deciding as a matter of policy that you want to interpret a statute in such a way that will force you to regulate in such a way that causes harm to the country, in this case by getting rid of the mercury rule. We think that that should be just per se unreasonable at step 2. If step 2 means anything, if the unreasonableness language of step 2 means anything, it should mean that it's not reasonable to interpret the statute in a way that, as a discretionary matter, requires use your discretion to interpret the statute in a way that will require you to do something that is welfare diminishing and harmful to the country. That seems like the core of what step 2 should prohibit. And then, as for the strategy of prayer, could go unanswered. Okay, so more generally, I want to say something about the tension between Chevron and cost-benefit analysis, because we really see them pulling in different directions across these regulations. So one position you could take with regard to this is on the Chevron side. in the presence of an ambiguous statute, CBA just has to give way. The agency should be allowed to do what it wants to. And I guess I want to say, having lived through Trump, is that really what we want? Do we really want this sort of unfettered discretion on the part of the administration in the presence of ambiguous statutes, of which there are very many? On the CBA side, you might say, well, maybe CBA should constrain agencies no matter what, and they should always be bound by cost-benefit analysis, and they shouldn't be allowed to sort of Chevronize their way around it unless the statute really is unambiguous. And the question there is, will courts be able to police that? And then I'll finally say, maybe there's some possibility of a middle route, some way of navigating this path, but if there's a crisp answer there, we haven't found it yet. Chevron and CBA sort of continue to be in tension, and sometimes it's a good tension, but and I think that the Trump experience proves that, but nonetheless, it will be a hard tension for courts and agencies to sort through going forward.
All right, well, thanks very much. That was precisely within time. Very impressive. All right, next we have Professor Lawrence from Emory.
So I'll actually be sharing a YouTube video that Professor Lawrence had pre-recorded. So just one moment.
Becky, I think we need volume.
Sorry about that. Let me check settings.
Well, hi, everybody. My name is Matt Lawrence.
Can everybody hear that now?
Yes.
I'm an associate professor of law at Emory University School of Law, and I'm actually coming to you from the past. I'm recording this on Tuesday, and my wife is about to give birth, so Friday morning I'm either not going to be able to make it or I will not be able to make complete sentences, and the editors at Duke were kind enough to let me pre-record this. I want to say thank you to all the other presenters, to the conveners, to the editors. This has been a fantastic symposium experience. I can't believe how quickly and thoroughly the editing process went, but let me dive right in. My topic is Congress's domain, appropriations, time, and Chevron. I'm going to make two, oops, that was an accident. I'm going to make some stray highlighting marks, but I'm going to make two core points. The first is a descriptive point. I'm going to talk about appropriations, and I'm going to say that we should divide in our minds between annual and other short-term appropriations and permanent and other long-term appropriations when we're thinking about the separation of powers, because annual appropriations preserve a domain of congressional power and permanent appropriations shrink that domain. I talk a little bit more about that distinction, where the lines are in the paper. I won't go into it now, but that's my core point descriptively. Annual, preserve separation, preserve congressional power, permanent, shrink. And my doctrinal recommendation will be that while courts have taken varied approaches to Chevron for appropriations, I'll recommend they disfavor deference for permanent appropriations, but not for annual appropriations. And that's going to be in light of their very different roles in the functioning of the government. So to start things off with some grounding, with the frame, anyone attending this conference knows that the Schoolhouse Rock version of the separation of powers is two-dimensional, although very interesting. And one important dimension that you have to add is the fourth dimension, is time. Oftentimes, Congress and the Senate, maybe with the president, maybe over a veto, they create a statute that then is entrenched there on the statute books. and empowers an agency. It's a delegation that empowers the agency far into the future. 30 years later, 40 years later, 50 years later. This is why Guido Calabrese suggested courts take away some statutes. I'm not going to get into that. The point is, when we teach administrative law, we sometimes wonder, what is the future role for the Congress, for the House and the Senate? What is the future check on agencies once they're empowered? And that's where appropriations come in, because appropriations actually preserve a really vigorous area of congressional oversight. Here is the appropriations power for annual and permanent appropriations, but I know there's a lot there. I want to start you down here at the bottom, at the key, if you look at the bottom left, with a really fundamental distinction in appropriations law between authorizations and appropriations. So an authorization is just what if you're not in appropriations, you just think that's the law. It is a law that empowers an agency or requires an agency to spend. We call that an authorization. And because of the appropriations clause, an authorization is not alone sufficient to allow the agency to spend under the Constitution. Constitution requires an appropriation, which requires you name a source of funds. There's purpose, there's some other requirements I talk about in the paper. The upshot is that Congress can create an authorization that even requires an agency to spend, but not appropriate the funds, and instead appropriate them 1 year at a time. And in that case, the Congress actually has to appropriate the funds for the agency to comply with the law. That's a fundamental distinction. And what that allows is that oftentimes, if you go up here to the this top left box, oftentimes Congress creates a statute in permanent law that permanently authorizes an agency to do something and gives it some power, but it appropriates funds for the agency and for the program 1 year at a time. And that winds up giving the agency that kind of enduring influence to administer the program, but also future Congress's influence, because both the House and the Senate now can unilaterally block funding. They get a veto, an appropriations veto over the agency's funding, because they're both necessary every single year to fund the program. And that allows Congress to watch over what's happening pretty closely, because the agency's worried not only that next year won't get funded, but there might be a reduction in its funding. It preserves this area of congressional influence and oversight over agencies. That's what annual appropriations do. At the same time, though, flip over to permanent appropriations. A permanent appropriation provision gives the agency power to spend constitutionally without congressional approval going forward. It's on the permanent statute books. And that's basically giving all of the power to the agency, and that leaves the House and the Senate out. The permanent appropriation takes away from Congress that ability going forward to threaten the agency with reprisals through the appropriations process. So that's all what I mean when I say that annual appropriations and permanent appropriations play contradictory roles in the separation of powers. So what does that mean for Chevron? Like I said, courts have taken different approaches to Chevron for appropriations. I think to understand Chevron for appropriations, we need to decouple two things Chevron's doing. So another picture, and again, start at the bottom left at the key. I just want to focus in. When Congress creates a delegation, there's actually two kind of authorities going with that delegation. The clear law is empowering the agency, but by default, the ambiguity in the delegation empowers courts because they get to interpret the ambiguity. So that's our default top left. Straight line, clear law, delegation empowers agency, but squiggly line, the ambiguity empowers the court. But with Chevron, what happens, of course, first thing that happens is now that the agency interprets rather than the court. But a second important thing happens when you apply Chevron, which is that you take away stare decisis. You take away the solidifying effect of that first interpretation. So instead of courts deciding, but then locking in their interpretation, we have agencies get to interpret, and they can change their interpretations. And that's really a separate effect from deciding who interprets, deciding that the interpretation can't be sticky, because, of course, the agency can't change it. The Biden administration can't change the stickiness of its interpretations. The next administration will be able to change them, and so on. So what that means when you put it all together is how Chevron works with appropriations is starting up with annual appropriations, not that big a deal, but a little awkward to refuse Chevron deference for appropriations. Not that big a deal, because no matter what, when it comes to the ambiguities in appropriations, the House and the Senate can watch over what the agency does, and they can punish misinterpretation, bad interpretation, whatever. They can punish things that happen that Congress doesn't like. They can punish that through the appropriations process the next year. So there's this ongoing congressional oversight in the annual space that makes the role of courts less important. Also, annual appropriations are very transient, hard for judicial review to come in. So I won't dwell on that, but I do have some thoughts. As for permanent appropriations, much bigger deal because those go on the books permanently. And whenever Congress gives away some of its power through a permanent appropriation, Chevron for that increases the gift. It shrinks Congress's power even further. And that's what I have that here. And it does a second thing, and this is what I want to focus on, at least in this talk. To this point, you might be thinking, I'm suggesting annual appropriations good, permanent bad, but I'm not suggesting that. There's a really good reason for permanent appropriations. The strongest reason is stability. You want a permanent program. You need people to rely on it. Something like new property that can't be dependent on the annual congressional cycle. That's the best reason for permanent appropriations, and that reason is undermined if we apply deference to permanent appropriations. Because if you apply deference to permanent appropriations, it means that the meaning of those ambiguities in the permanent appropriations is always up for grabs. It can always change. We saw a version of that, the King v. Burwell case, where there's the premium tax credit, within the statute. Well, if you say that it's up to Chevron deference, that means each administration has a switch that can turn on and off the funding. And so the best argument for permanent appropriations is actually undermined by applying deference. And that's one reason I think that doctrinally courts could not only should, but could say that it doesn't make sense with the kind of Chevron intent assumptions to defer to permanent appropriations when we should assume when there's a permanent appropriation that Congress was actually looking for the meaning to be solid over time. And of course, there's more to it than that. The bottom line core point is, let's see if I can get on there. Bear with me. Don't cross the streams. When Congress creates a statute, there's the clear law, that goes to the agency. There's the ambiguity, that might go to courts, that might go to the agency. And then there's also the funding. And when there's annual appropriations, Congress keeps that. When it's permanent, Congress is giving some of that away. When you have deference for permanent appropriations, you have all of the different kind of sources of influence created in time one when a statute is created. All of them are going to the agency in time two. There's some downsides to that. There's upsides too, we talk about in the paper, but overall, recommend courts decline Chevron deference for permanent appropriations. Love to get questions or engage further on this. I have my Twitter handle and my email on this, and look forward to the rest of the symposium.
All right, thank you, Professor Lawrence, for that video.
All right, so that was remarkably well executed. Thank you, Professor Lawrence. Now we have Professor Choi from Minnesota.
Terrific. Let me just share my screen. And first of all, thank you to Christian and the editors of the Duke Law Journal and to Arti for moderating. This is a terrific symposium so far, and I appreciate being invited. So this is a paper about how judicial deference affects agency rulemaking. There's a lot of literature discussing how judicial deference affects courts. There is less literature, although some of it was written by Chris Walker, about the effect on agency rulemaking. And the particular hypotheses that this paper studies are, first, that more judicial deference will allow agencies to make rules on policy grounds rather than legal grounds. So there's been a suggestion, most famously perhaps by Don Elliott, that before Chevron, the EPA was run by lawyers who tried to find the single best interpretation of the statute. And then after Chevron, the EPA was run by administrators and scientists who would figure out what the best policy was. So there's the Peter Strauss idea of the Chevron space, and within the Chevron space of reasonable interpretations, the agency, as a result of Chevron, will start trying to maximize policy goals rather than legal interpretation. The second hypothesis has to do with procedural effort. So this is effort expended in complying with APA requirements. For example, reason giving in preambles, writing detailed preambles, engaging substantively with the public in notice and comment. Now, intuitively, you might think that more deference means agencies have more freedom to do what they want, and maybe they'll get a little bit lazier and they'll expend less procedural effort. The paper argues to the contrary, that we should expect more procedural effort at a higher level of judicial deference. So one reason perhaps is the explicit linking of judicial deference and APA procedures. You see this in Michigan EPA versus EPA, Encino motor cars. But the paper actually argues that even if deference is separate from APA procedural requirements, so even if deference is a matter of statutory interpretation and the APA is a separate thing entirely, we should expect agencies to exert more effort at a higher level of deference. And so it introduces this theoretical model where an agency picks the optimal level of procedural effort to maximize its expected utility, which is a function of the likelihood that a regulation will be upheld. And the way to think about it is that procedural effort essentially serves as the price of deference. And the price is more worth paying the more deference you get. So conceptually, if an agency receives very little deference, the agency would say, well, why should I exert all this procedural effort? I may not be upheld anyway. Whereas at a higher level of deference, say Chevron versus Skidmore deference, the agency would say, okay, if I put all this work in, I'm likely to be upheld. I buy this additional level of deference, and therefore the price I'm willing to pay, the amount of effort I'm willing to exert should increase if more deference is given. So these are the theoretical suggestions, but of course what this paper tries to do is test these hypotheses empirically. So of course, you know Chevron deference, you know Skidmore deference, but have you heard of national muffler deference? So national muffler deference is a specific historical form of deference that applied to some tax regulations. And it said that they should be upheld if they're reasonable when applying this laundry list of tools of statutory interpretation. So because the laundry list was so specific, national muffler was thought to be less deferential than Chevron, even though they both talk about reasonableness. And it was also thought to be more deferential than Skidmore. So it's kind of an intermediate deference standard that applied historically in tax law. Now, the big difficulty in assessing the impact of Chevron is that when it came down, nobody knew how important it would be. So it wasn't a very clean event in terms of a natural experiment. Moreover, it applied very broadly. So there wasn't a clear treatment and control group. And as a result, even though certain things happened in administrative law, maybe they were because of law and economics in the 80s, or the new textualism, or the rise of cost-benefit analysis, we didn't really have a clean treatment and control. Now, what national muffler gives us is that natural experiment. So before 2011, these tax regulations were subject to national muffler deference. In 2011, the Supreme Court says, we are not inclined to carve out an approach to administrative review good for tax law only. That's in a case called Mayo. So that means no more national muffler. Now tax regulations are subject to Chevron deference as well. And this gives a nice natural experiment where we can see, okay, we have these tax regulations that are the treatment group. We have all other regulations, which are the control group. What happened to tax regulations that didn't happen to the other regulations after Mayo came down? So the data that the study uses are from federalregister.gov. This posts all rulemaking documents for the past 20 years, around 70,000 in total. And I focus on regulatory preambles, so the reasons that agencies themselves give when they are writing these rules. The key metrics are word count and term frequency. So term frequency is the frequency of terms of a particular type in a document, the number of terms divided by total words in the document. And it gives you a proxy for, say, a legal versus a policy orientation. So does the preamble discuss the statute? You know, we construe section 61 as blank, or does it discuss normative issues like fairness and efficiency? So the latter would suggest more of a policy orientation. The methodology is what's known as difference and differences. So here we have our treatment group, which is this red line. This is the group of tax regulations. And then we have our control group, all other regulations. And so using difference and differences, we try and extrapolate. So this dashed green line is what we think would have happened to tax regulations absent the treatment of Mayo. So absent the higher level of deference, we think it would have proceeded along this line. And then this is what actually happened to it. And so we say that this controls for the difference over time that applies to both groups. It controls for the static difference between the groups, and it allows you to isolate that treatment effect, the difference between the actual and counterfactual path of these tax regulations. So a clean difference in differences results shows parallel trends prior to the treatment, and then after divergence. Okay, so here are basic graphical results, no controls. And you see that relatively clean difference in differences results. Before Mayo, the tax regulations and other regulations are relatively parallel. And then after Mayo, boom, a big uptick in normative terms in these tax regulations. So all of a sudden, there's a lot more discussion of fairness and efficiency and all of that. And that supports that first hypothesis. For statutory terms, you see the inverse. So before, the IRS tended to discuss statutes more extensively than other regulatory agencies did. And then after Mayo, they kind of converge. So that difference goes away. On top of that, I have two proxies for procedural effort. One is preamble length, so how long are the preambles that agencies write? And before, these trends are not exactly parallel. The paper talks about this at length and introduces various controls for this issue. I'm happy to talk about them if anyone is interested. But after you do see this basic result that there's an increase in the length of regulatory preambles at the IRS after Mayo. Another measure is the frequency of references to commenters. So how much does the agency engage with commenters during the notice and comment process by responding in the preamble? And here we don't really see much of a result. These data are very noisy and there's barely perceptible any increase. So absent controls, it seems like there may not be as strong results here. But of course, what we'd really like is to have those controls, so to do a regression. And in this paper, I do what's called a two-part regression. It's common in public health economics. And the two-part regression separately models the likelihood of using any terms of a particular type at all. So the likelihood that a preamble has any normative terms, any statutory terms, and then conditional on having any, the frequency of those terms. So that's perhaps a proxy for the intensity of the discussion of, say, normative or statutory issues. So the two-part model, I won't get into it in detail, but it deals with some issues with the data as well, because natural language data are typically log normal instead of normal. So you don't want to use ordinary least squares regression. You want to use something like this. It also allows us to control for a bunch of things. So time trends, regulation length, the reading level of the preamble, the party of the sitting president, the type of regulation, and various difference in differences controls. So with this model, the regression results are largely supportive of the two hypotheses. So if you look at normative terms, there was a big increase in the likelihood of using any at all, an increase in the intensity of discussion if they are used. And for statutory terms, you see the opposite, a decrease in the likelihood of using any at all, and a decrease in the intensity of that discussion. There's an increase, these are all statistically significant so far, in the average preamble length after Mayo. And then for commenters, there's a near zero effect for a preamble's likelihood of discussing commenters at all. But conditional on discussing commenters, the intensity of that discussion substantially increases. So this would be consistent with, say, before Mayo, the IRS kind of paying lip service to comments, saying, yes, we received comments, but not getting into details. And then afterward, being more likely to substantively engage and respond to those comments or explain why it didn't change the regulation in response. And these results about procedural effort kind of correspond with qualitative results that I've seen regarding shifts in IRS attitudes after Mayo. So there was one chief counsel at the IRS who said, with great power comes great responsibility. After we get Chevron deference, now we have to be careful, we have to be responsive, we have to really take notice and comment seriously. So qualitatively, the results seem to correspond with these quantitative results as well. So what are the implications? First off, that Mayo matters. There is some literature suggesting that judicial deference is irrelevant. And this paper suggests that even if that's true at courts, it still affects how agencies write their rules. And so it matters in that respect. There's a tax exceptionalism story here. So National Muffler made a big difference in tax administration. And after National Muffler goes away, we should expect convergence between tax and other areas of administrative law. Finally, with respect to the two hypotheses, It supports the theory that Chevron does encourage policymaking rather than legal interpretation. You could like this or dislike this, but as an empirical matter, it seems to be happening. It also supports the hypothesis, although less strongly, that Chevron incentivizes greater procedural effort. So you could like this or dislike this. Again, you could think that this leads to more ossification of agency rules. Or if you like hard look review, you might be inclined to support Chevron as a result of this. So again, it's just an empirical finding, less normative here. So thank you, and I will flip it back over to the comments.
Terrific. Well, thank you, Professor Choi. And we have a bunch of questions in the chat. And one of the first questions, I should say, is somewhat related to a question that I had as well. So this goes to Professors Wadhia and Walker. And it goes to the question of the level of generality of your recommendation. So it sounds like you're not going to go all the way to the bright line kind of approach that Professors Nielsen and Hickman might prefer with respect to adjudication. So is there a test that courts should use in terms of outside the immigration area if they want to apply your approach? And more specifically, there is also in the chat a question, I guess in immigration, there's a lack of a record, there's a lack of knowledge of how the system works and so forth, which very much supports your idea that there is no expertise in the immigration system. But I suppose I wanted to abstract that out and ask whether there's a test that you would propose for more generally in adjudication.
Shoba, you want to take a stab at it? You want me to, or yeah?
I mean, I'll do a minute and then I want to give it to you, Chris. Maybe I'll answer the second question. Well, actually, I have the same answer to both questions, and that is that our solution really, which aligns to with Hickman and Nielsen's paper, is that what should be given Chevron deference is notice and comment and rulemaking. And I think that some of the problems that are identified just further solidify that point. So our bright line test in the adjudicatory context is something less than Chevron, maybe like a Skidmore deference. So, Chris?
Yeah, and we're obviously only focused on immigration. And I know we get this, we have gotten this comment before, like, you know, is this more? And so first, we think that the immigration context is the best context, adjudication context, to get rid of Chevron. Now, if you had to push me, am I willing to get rid of Chevron adjudication more generally? I think the arguments are better in mass adjudication than in lower volume adjudication. I think the arguments would play out differently, for instance, at the SEC than they would at the BIA or in veterans or in other kind of contexts. And I think that does matter. I'm not willing to go all the way like Kristen and Aaron do, and quite frankly, I think even Kristen and Aaron walk it back a bit as well. About all adjudications, and so that's why we really wanted to do a deeper dive in immigration, because the expertise arguments in immigration are just so much weaker than a lot of other contexts.
Great, thanks so much. Now we have a question for Professor Masur, I believe, from Professor Rasmussen, and I'm a little, it's complicated, so I think I'll try to allow Professor Rasmussen to ask the question directly. And the question is, how do I do that? Becky, maybe you could help me on that one.
Yeah, of course. Let me take a look.
This is Eric Rasmussen of Indiana.
All right, Professor Rasmussen, you should be allowed to talk now.
Okay, I can talk but not be viewed, I guess, so it doesn't matter that I didn't comb my hair. But you can hear me, it sounds like, from the giggles. Okay, yeah, the argument that cost-benefit analysis should rule is one I like as an economist. But it makes me think there are two kinds of ambiguity in Chevron. And maybe you could talk about that. The first type is that everybody agrees the statute is ambiguous, maybe even gibberish or incoherent. And then your argument really applies quite well. The agency and courts have to make law. It's only a question of which of them does it. And you could say cost-benefit analysis should determine it. You're looking for good policy. But I think, and that's really what the conventional Chevron argument is. The one I think is kind of silly, that Congress intended to be incoherent and let the agency do whatever it wanted. But the other one is that the ambiguity is different. It's that some people think it unambiguously says X, and others think it unambiguously says Y, but they both agree each other's arguments are reasonable. So it's a difference in something like interpretive philosophy or something like that. And then your argument doesn't apply, because then it's a question of when reasonable men can differ on what the statute says, whose interpretation should follow. So I wonder if anybody's made that distinction before, or how you think it might apply to your argument.
Thanks, that's a nice question. I mean, we just talk very briefly about sort of different ways of thinking about what ambiguity means for Chevron purposes and different ways of thinking what unreasonableness means. But I guess I'll say, I think that our argument applies to your second category as well. So if an agency thinks that a statute unambiguously means something, they should argue, at Chevron step 1 that it unambiguously means that thing. And maybe they argue at Chevron step 2 that it, even if they're wrong, they think the best interpretation is that thing. And so then it goes to the court. The court thinks that it unambiguously means something, then they should decide that at Chevron step 1. Our point is just that if in fact there are two equally good, if the court believes that there are two equally good meanings and that the arguments for two different meanings are equally strong, and thus it is ambiguous as between those two meanings what the statute should be, or how the statute should be interpreted, then it's unreasonable to pick the one of those two meanings that requires doing more harm than good to the country, diminishing welfare, and foregoing the other equally good meaning that would involve actually doing something useful for the country, improving welfare. I mean, there's been a lot of debate about what unreasonableness means in the Chevron context, but that's like at the core of what we think about in terms of unreasonableness across other areas of law. We talk about unreasonableness in lots of other, tort law and various other places. Unreasonableness means don't force yourself into the choice that's going to do more harm than good. And so we think that that same principle ought to apply here. And I do think it applies to that second category as well.
Oops.
Oh, and Professor Ray, I think you're still muted.
Sorry. We have a bunch of questions in the chat, and so with apologies to Professor Hickman, I'm going to just focus on the chat for just a moment, and then we will go to Professor Hickman. So there's a lot of discussion about immigration, and I would say it's related to some of the other questions that are for Professor Choi. And this is essentially at a high level, should we be agency agnostic with respect to deference to adjudication in agencies? And does the IRS example suggest that the court does want to be agency agnostic? It doesn't want to parse these differences as a positive and normative matter. How should we think about that set of questions? And perhaps Professor Hickman can answer that as well, given that that's part of her paper. So perhaps I will turn it over to all of those folks who wrote either on immigration or tax or Professor Hickman. So let's start with immigration, since I have to say that it sounds like Professors Wadhia and Walker, you may have a little bit of a tension in terms of your desire for a bright line approach across agencies?
Yeah, I mean, I don't think between us, I mean, we really are just focused on immigration adjudication, I'm guessing like we actually haven't tried to together try to generalize it beyond that. I would say that, as I mentioned in the introduction of my remarks, that I'm not a huge fan of the Supreme Court doing this. And I think Shoba probably is more receptive to that. And one of the reasons why it gets to the question Eric was asking is that I've read a lot on administrative law exceptionalism, and I don't think that we should be carving out things left and right, based on rationales of expertise. We meaning the court. I think that that's something that's a better thing for Congress to do, or for the executive branch to do internally. And so that's one additional reason, in addition to stare decisis, that I think that's problematic. That said, Kristen and Aaron in their paper, I think, make some good arguments for why immigration adjudication shouldn't be treated the same. One being that it's not APA formal adjudication, and that I think there is a principled line you could draw, that a court could draw, saying the reason we're going to stop giving deference to immigration is that we've long held that it applies to notice of comment rulemaking and formal adjudication under the APA, but maybe we shouldn't apply it to less formal means. And maybe we can kind of carve back Mead here not to apply. So it still would apply in an ALJ classic formal adjudication context like at the SEC, but it wouldn't apply at places like the BIA or the PTAB in the patent context perhaps as well. So that's maybe Kristen wants to, I don't know, but do you have anything more? The kind of reaction to that? Or?
Yeah, I don't have a lot more to add. I mean, we are very focused on immigration. And I agree with Chris that I think once we go down a rabbit hole of trying to create lines between in expertise itself, that can be problematic. And what we didn't get to in our short time beyond expertise is a sort of hearty argument, I think, about the lack of deliberative process. So I think if you really look at the values of Chevron as a whole, immigration adjudications are just suspect, to say the least.
So I would say that there is some debate in the chat over how much record is kept of immigration court proceedings. People are going back and forth a little bit on that question, whether there are full records. And I can't answer that question, but perhaps that's something to keep in mind. Professor Hickman, would you like to comment on any aspect of this this question of how we draw the line as to which agencies, if any, get deference in adjudication?
Oh, I have all kinds of thoughts, but since John Choi is actually on this panel, I'd kind of like to give him a chance to answer the question with respect to tax.
Sure.
And then if there's time, I'm happy to weigh in.
Okay. And you had a question as well, I guess.
Yeah, but let me give John a chance to answer first.
All right, great.
I mean, I do appreciate that because Kristen's like the world expert on tax exceptionalism, which is what this is all about. So, there's a long literature and case law about whether tax should be treated differently than other agencies, the IRS should be treated differently from other agencies. And I think historically, if you go back to like the 70s and 80s, a lot of people thought that it should because, it was like a complicated area of law. The IRS has a lot of expertise. Maybe there's justification for treating it differently. And then more recently, perhaps thanks in large part to Kristen, it seems like the scholarship is turning the other way. And people say, tax people think that they're special and that tax law is so complicated, but criminal law people think that they're special and criminal law is so complicated, and immigration is complicated, environmental is complicated, everything is complicated. And can you really draw these distinctions between different areas of law based on what you believe to be characteristics of these different areas? Whereas perhaps there's a stronger case to be made for procedural differences. So if in immigration we have this different process, then you could have like a cross-agency principle that could apply evenly to all agencies and perhaps draw distinctions there in the level of deference that ought to apply. The latter seems more appealing than the kind of classic arguments that, you know, like tax is so special.
Okay, Kristen, would you like to follow up on that or
No,
wait?
at least regards this question, I will simply say, and I will talk about it a little bit when Aaron and I present our paper this afternoon, but I've argued against exceptionalism for my entire career with respect to this, unless Congress indicates some reason otherwise. Which actually, you know, that's one of the things I like about Chris and Shoba's proposal is, you know, they don't just leave it up to the Supreme Court. They bring in the possibility of Congress signaling an intention with respect to immigration cases. You know, I'll talk more this afternoon about stare decisis. The one problem in the adjudication context really comes down to my way of thinking, how you deal with the stare decisis question, particularly in immigration, given that there have been so many cases where the Supreme Court has deferred under Chevron to the Board of Immigration Appeals. Do we have time for me to ask my question?
Yes, we absolutely do.
Excellent. You know, so my question actually is with respect to Chris and Shoba's proposal, you know, which, you know, I greatly appreciate their paper. I think they bring in a really great perspective about not just looking to the Supreme Court, and I really appreciate that. One thing they did talk about, though, was the possibility for the agency itself to back away from Chevron deference, which is essentially the Chevron waiver question that is percolating around the circuit courts right now. As I know that Chris and Shoba are aware, several circuits have concluded that Chevron is a standard of review that can't be waived by agencies. And the en banc 10th Circuit will be taking up that question in Aposhian versus Barr, which is not an immigration case. You know, but so we might get to a circuit split about whether Chevron is waivable by an agency. But so I wonder to what extent, Chris and Shoba, you think that if the courts perceive Chevron as a standard of review, then does that limit the ability of DOJ and BIA to avoid Chevron deference, or are there things that they can do to avoid Chevron deference, even if they can't outright waive it?
Yeah, I mean, the main thing they can do is they can shift their policy making, major policy making, from adjudication to rulemaking. They could pledge from the outgo, you know, Attorney General, soon to be Attorney General Garland, or has he already been confirmed? No, he's not yet. He could just announce, right, that we've decided to make our major policy making decisions not through guidance, not through adjudication, but through rulemaking. And that often be joint rulemaking with DHS. But that's one thing they could do to do that. They could obviously not ask for Chevron deference, and then a court would have to decide whether, you know, obviously the non-citizens in court's not going to argue, oh, court, you have to consider deference, because they don't want deference either, right? So the court would have to sua sponte decide whether to apply deference. And as Tom Merrill's mentioned earlier today, you know, when agencies don't ask for deference, courts oftentimes don't on their own decide to look at deference, right? So I think those are kind of the key moves that we have. If the world weren't so crazy right now, I really hoped that at the AG hearing in the Senate Judiciary Committee, that people would raise this issue of, are you willing to rethink whether you should use rulemaking? And by the way, the main reason I was so thrilled to do this paper with Shoba is she's written a definitive book on the importance of using rulemaking instead of guidance for prosecutorial discretion in the immigration context. So she's really been one of the leading figures of encouraging this. Now, I just want to add one more thing. One of the huge side benefits, of course, of moving this from adjudication to rulemaking, if you're President Biden or Attorney General, soon to be Attorney General Garland, is that the next administration can't undo an agency's interpretation as easily in rulemaking, right, than adjudication. I think that's critically important. If you look at what happens at the AG certification process, is it's a flip-flop back and forth. And I think that's really problematic for stability in the law and predictability, that non-assistants have to kind of navigate that each change of presidential administration, you could have a change in a day back to the opposite approach. So one more reason for major immigration policy making to be done through rulemaking instead of through adjudication.
And thanks. Can I just jump in for a minute?
Absolutely.
And that is, yeah, I appreciate the question, and I think it's less a conceptualization of a waiver for me, and more so a sort of shift. There's a lot of discretion that the agency itself has about how they make policy. So maybe we are optimistic, right, that we can change behavior within the same agency and move their policy making from adjudications to rulemaking. Chris is absolutely right that there's a lot of gymnastics that happens around core concepts because of the back and forth the board has with itself on agency interpretation as well as AG certification. You know, we're seeing a signaling just in an executive order issued by President Biden this week. There was an instruction through joint rulemaking within 270 days for the Department of Homeland Security and Justice to craft and promulgate rules around particular social group, which is one type of asylum claim. And that's just an example of a standard that's just been volatile in the agency, and I think will benefit greatly from joint rulemaking.
Terrific. So we are almost out of time. I don't think I can ask, there are a few questions that really get into the details of immigration proceedings, and I don't think I can ask all of them. So rather than doing that, I'm going to ask a question of Professor Masur that you may or may not have an immediate answer to, which is, so all of this celebration of rulemaking by some of your colleagues on the panel, do you think at the end of the day that you would agree that rulemaking would be preferable to adjudication, given what you've said about the gymnastics that can be done with rulemaking as well?
I do think so. I mean, I think that there are a lot of procedural advantages to rulemaking along the lines that many people have pointed out. And so whenever possible, I think it's a good idea for agencies to try to use rulemaking. And I think all the reasons that other folks have spoken to, I think I would heartily endorse.
All right, so we have agreement. I don't know about Professor Lawrence, whether he could speak, probably cannot speak because he may be about to become a father. But thank you to all of you. Wonderful panel, much appreciate all of the incredible insights and empirical data that has been brought to bear. And I take it we are going to move directly to Professor Merrill's talk.